Hi, my name is Yogya Bhatia and I'm a legal intern at LEXIS and Company. Today I'll be talking about robbery and dacoity under IPC. Robbery. The term robbery, theft, and extortion are very similar to each other and they are often used interchangeably on a daily basis. But the legal implication of all the three terms is different. The Indian Penal Code has defined these terms very clearly. It has defined these as distinct crimes. Section 390 of the Indian Penal Code has defined robbery and has defined theft and extortion in relation to robbery. Before analyzing or understanding Section 390, first theft and extortion needs to be understood separately. Theft. Theft has been defined under Section 378 of the Indian Penal Code 1860. It says whoever intends to take dishonestly any movable property out of the possession of any person without that person's consent and moves it, he or she is said to have committed a theft. For example, if A is employed by B and entrusted by C with care of D's cash, dishonestly runs away with the cash without D's consent, then A has committed theft. In the case of Pyarelal Bhargava versus State of Rajasthan, a government employee took a file from the office and gave it to Mr. A and brought it back 2 days later. It was held that he took the property away with a dishonest or malicious intention, and that is enough to term it as theft. Essentials of theft. The essentials of theft are there has to be a dishonest intention to take the property away. The property should not be attached to the earth. It should be movable property as soon as the property is separated from the earth. It is capable of becoming the subject of theft. For example, if A cuts down a tree on B's ground with the intention of dishonestly taking the tree out of B's possession without B's consent, then as soon as separates the tree, he commits theft. The property must be taken out of the possession of another. A thing which is in the possession of nobody cannot be the subject of theft. The most important thing is that the property must be taken away without consent. There must be physical movement of the property. However, it is not important that it should be moved directly. For example, if someone cuts the string which is tied to the necklace owing to which the necklace falls, it would be held that he or she has caused sufficient movement of the property as required for it to amount to theft. Punishment for theft. The punishment for theft is defined under Section 379 of the Indian Penal Code 1860. It says that a person who commits theft shall be punished with imprisonment of up to 3 years or with fine or with both. Extortion. Extortion is defined under Section 383 of the Indian Penal Code 1860. This section says that any person who intentionally puts another person in fear of injury and dishonestly induces him to or her to deliver any valuable property or anything signed which can be converted into valuable security is said to have committed extortion. For example, if D threatens A that he will keep A's child in wrongful confinement and will kill him unless A delivers to him a sum of rupees 1 lakh, then D has committed extortion. Essentials of extortion. The essentials of extortions are the person committing the offense should be intentionally put the victim in fear of injury. The fear of injury must be to such an extent that it is capable of unsettling the mind of the victim and forcing him to give his property as in the above stated example. The person committing the offense should dishonestly induce the victim so to put in fear to part with his property. In the landmark case of R.S. Nayak versus A.R. Antole, a CM, promised the sugar cooperatives whose cases were pending before the government for consideration that the cases should be looked into if they donated money. It was held that fear or threat should be used for extortion, and since in this case there was no fear of injury or threat, it would not amount to extortion. Punishment for extortion. Section 384 of the Indian Penal Code defines the punishment for extortion. It states that any person who commits extortion shall be punished with the imprisonment of up to 3 years or with fine or with both. Essentials ingredients of robbery. Section 390 of the Indian Penal Code 1860 says that in all robbery there is either extortion or theft. The Black Laws Dictionary defines robbery as the felonious act of taking the personal property of another from a person or immediate presence against his will accomplished by using force and fear. Causing death, hurt or wrongful restraint or fear. Death, hurt, wrongful restraint or fear can be caused when theft is a robbery or when extortion is robbery. These two are explained below with the help of illustrations. When theft is robbery. Theft is a robbery when, in order to commit theft, the offender voluntarily causes or attempts to cause to any person death, subject him to wrongful restraint, cause hurt, or induce fear of instant death, wrongful restraint, or cause instant hurt. When extortion becomes robbery. Extortion becomes robbery when the person committing the offense of extortion put the other person in fear and commits extortion by putting that person in fear of death, instant wrongful restraint to that person or to some other person, and by doing so induces the person to put in fear then and there deliver the thing that has been extorted. Thank you.